Before we get started, I know Judge Thumma introduced us, but I'm Jennifer Perkins, and on behalf of the panel, Judge Winthrop and Judge Catani and myself, I wanted to say thank you to Northern Arizona University for having us here, and thank you to the parties for being willing to participate in this exercise. We are here for oral argument in our case number CV17-0761. These proceedings are being recorded, so we'd be grateful if each of the attorneys that comes forward when you come to the podium, you would introduce yourself and your client for purpose of the recording. As you all know, you are each side is allotted 20 minutes. The appellant is free to reserve some time for rebuttal, but that is up to you. We don't have our traditional clock, but we will have a very diligent bailiff here helping you keep track of that time with the cards from back in the day. His time will reflect the total amount of time you have remaining. As I said, it's up to you to keep track of your rebuttal. Please keep in mind we've read the briefs, we have conferenced the case, we're familiar with the record, and with that, I invite you to begin your argument.
Good morning, Your Honors, and may it please the Court. Haley Crawford on behalf of Sun Silver West Gallery. I have at counsel table with me Eric Frazier. I'd like to reserve 5 minutes of my time for rebuttal. The question in this case is, what is the bare minimum a city has to do before it can charge a landowner with a zoning violation? To take enforcement action against Sun Silver West Gallery, SEDONA needed to determine that the property's actual existing conditions and uses violated the city's zoning laws. But in this case, SEDONA explicitly admitted to the Board of Adjustment that it had not verified the actual property conditions at the gallery. Instead, it relied entirely on a withdrawn rezoning application that showed the proposed uses for the property.
Ms. Crawford, is it your argument that the board did not have authority to proceed to determine whether there was a violation or not?
Correct, Your Honor.
Can you point to me in the Board of Adjustment transcript or the Superior Court argument where you and your clients argued that the board did not have the authority to to resolve these violations?
Yes, Your Honor. Specifically, if you look to the verified complaint, which is index of record number 2, and in particular pages 53 to 57, and the prayer for relief, that is where we explicitly asserted that the director and the board erred. The director erred by issuing these notices of violation, and the board erred by upholding them because there was no evidence and they had relied solely on this withdrawn site plan. And had failed to verify the actual conditions of the property. And on that basis, we asked them to reverse the Board of Adjustment order, finding that there was evidence to uphold the corrective actions, right, D1 through D7.
At the Board of Adjustment level, it seems to me the entire argument presented was one based on equitable estoppel and vested rights, the same arguments that were made in the Superior Court. Can you point me to some place in the Board of Adjustment proceedings where the property owner, through counsel, argued that the board did not have authority to proceed with these notices of violation?
Yes, Your Honor. In the Board of Adjustment transcript, if you look at appendix page 170, and that is the appellant's appendix, you'll see the staff's introductory remarks said, the board should focus on what the director relied upon in arriving at her decisions and whether those decisions were appropriate. Our contention is that the director did not have the appropriate type of evidence. She had not found that the actual existing conditions were in violation, which is a jurisdictional prerequisite to taking enforcement action, and therefore the board could not uphold that action.
Isn't making an equitable estoppel argument premised on, isn't there an assumption that there's a violation? What would be the basis for arguing you're equitably stopped from pursuing this because we were told this is okay, doesn't that assume that there's a violation?
Yes, and I believe that's why it was offered as an alternative argument after these other arguments, assuming that you did not prevail on the initial issue, which is...
But if you're making that argument, aren't you conceding that there is some evidence that of noncompliance? And is your position that there necessarily had to be a physical inspection, or just that there wasn't enough evidence even without a physical inspection?
I'll answer your second question first. Our contention is that there had to be some verification of the actual existing conditions, whether that be through a physical inspection or otherwise. We're not asking the court to affirmatively decide that, but nobody is disputing that under issue number 1, the zoning director is required to find that the actual current conditions of the property violate the zoning laws, and that just didn't happen here. They relied on a withdrawn rezoning plan, which doesn't even purport to be evidence of the existing conditions. So our contention is that is not the type of evidence that can trigger your right to pursue an enforcement action against the landowner.
And it's not a concession to be making an argument, an equitable estoppel argument? Aren't you essentially conceding that there's at least some evidence that of a non-conforming use if you're making an equitable estoppel argument?
No, Your Honor, I don't believe that's an admission, because the equitable estoppel argument is also addressing if disputes over how to interpret the conditional use permit. So if you agreed with our arguments about how it should be interpreted, there would be no need for an equitable estoppel argument. So it's a layered alternative argument.
Was there ever an argument, we are absolutely in compliance with the whatever, I've forgotten which year it was, the CUP? I didn't see that anywhere in your opening brief or in the reply. I didn't see any assertion that we were absolutely in compliance, and if they had just come and inspected the property, they would have seen that we're in compliance. Was that type of argument made anywhere below? I don't see it being made on appeal. Was that made below? We are absolutely in compliance.
Yes, Your Honor, and I would direct your attention to the appellee's appendix of record at APX 286, and that is where in a transcript we asserted that our position is that we believe that we're not in violation. How the gallery property has been used is consistent with the 1992 plan, the 1993 site plan, and the building permits that have been issued.
Well, can I direct you back to the point where I think you started, which was you said that the zoning administrator had no information to indicate that there had been a violation. When the zoning administrator made her statements to the Board of Adjustment, she indicated that the property owners, she had the site plan up, and she also indicated the property owners had indicated that those conditions showed not only prospective plans, but also existing conditions that were in fact in violation. Now, our job is not to weigh that evidence, and the Superior Court's job was not to weigh that evidence, but it was for the Board of Adjustment to determine the credibility of the various positions advanced by the zoning administrator versus the property owners. I assume you'd agree with that.
So there was not actually the site plan presented to the Board of Adjustment. On this record, the site plan is not contained in the record.
It's certainly referenced. If you read the transcripts, it's certainly referenced as being up on being displayed, and there's extensive back and forth questioning and discussion between the zoning administrator and Mr. Slavin and the chair and other members of the board about what they're seeing.
Yes, Your Honor. I do believe if you examine the record closely, what they were looking at was the chart summarizing the comparison between that withdrawn site plan and the requirements of the CUP. So the director presented as evidence a chart summarizing her findings based on her review of the 2015 site plan. But that site plan is not actually in the record, and it does not appear that the board actually had a chance to independently review that. So getting to your point about it showed existing and proposed uses, we don't know what it actually showed because it is nowhere in the record. We have to rely solely on the director's characterization of what that plan showed. And our contention is not that that is just a credible evidence issue, but also that it's a problem for giving you jurisdiction to proceed with enforcement anyway. What gives you the ability to look at a rezoning submission and then independently take that information, which was withdrawn, and use that as a basis for charging a landowner with a separate zoning violation?
So just to kind of circle back to what I think your legal argument is, and I'd like you to address, if you can, the issue raised by Applee, which is this argument that the director somehow acted in excess of her authority was really not raised before the Board of Adjustment and therefore is waived. Can you address that, please?
Yes, Your Honor. As we covered in our briefing, we do believe that this issue was raised. We discuss it at the opening brief, page 29, note 59 in particular, as well as the reply at pages 7 to 9.
Which is the strongest point? I'm looking at your reply. What's the strongest argument that would lead us to believe that it was raised? Which of those points?
I think our strongest citation is actually from the opening brief at 29, note 59. There we cite to the Index of Record 2, the verified complaint, at pages 53 to 57, and the prayer for relief.
But that's before the Superior Court.
Yes.
I think the question has to do with the argument that was raised at the Board of Adjustment, because that's what we need to focus on.
Yes, Your Honor. Before the Board of Adjustment, we did raise the issue of whether the director had properly determined that a violation existed. Although it may not have been crafted or articulated exactly the same way, we do think the touchstone of waiver here is fair notice. And if you review the full record, it's very clear that everyone was aware that we were challenging the director's reliance on the withdrawn rezoning plan to find those violations, and also their failure to verify the actual property
Let's
conditions.
assume, just hypothetically, that the withdrawn application had photographs that showed that there was a building that was 5,000 square feet too large, and that was submitted. The application's withdrawn, but it's pretty compelling evidence of what's actually there. Are you saying it's improper to rely on it, even though they've seen it, it's there, it's something that was submitted by the party? That's not something that could be considered?
No, Your Honor. That could be considered under the facts of your hypothetical. If I understand it correctly, you're saying that they would have submitted a photograph that documents the actual condition, and it would be clear from the description of it that it documents the actual conditions. The problem here is that we are relying on a summary of a site plan that we don't have. We don't know exactly what it showed. The board didn't know exactly what it showed. And although it says it showed existing and proposed uses.
But you're agreeing that they can rely on it. It seems to me then it becomes a question of how reliable was it? And that starts getting into the weighing evidence realm that we generally avoid.
I do not believe it was appropriate to rely on this particular site plan, given the purposes for which it was submitted. I do believe that there are scenarios where you could submit information in the context of a rezoning, and a municipality could rely on that to find evidence of
you're
the
agreeing
violation.
that you could have in your view, the fact that there wasn't a physical inspection isn't necessarily dispositive. You could rely on other evidence other than a physical inspection by the administrator.
Correct. But in this case, we do believe it is dispositive.
I've got a lot of questions, but I hate to interrupt your argument. Please go ahead.
Sure. So I'd like to talk a little bit about credible evidence because it ties into the waiver issue. SEDONA does not dispute the merits of issue number one. They don't dispute that the director is required to verify the actual existing conditions. They don't dispute that the gallery itself was not inspected, although other properties were, the gallery was not. And they also do not dispute that every other notice of violation in the record was preceded by an inspection, and that this has been their past practice. And this makes sense because zoning regulation is in tension with the common law private property rights.
But it makes more sense to me in the context of someone saying, we are in compliance, and you haven't inspected. If you had inspected, you would see that we're in compliance. But I don't see anything that suggests that that was an argument that was being made to the board. When the primary argument is equitable estoppel, it seems like the exact opposite of saying somebody should have inspected and you would see that we are in compliance.
I wouldn't necessarily describe equitable estoppel as the primary argument that was asserted below.
But would you agree that that at least suggests that there's some, at least a modicum of evidence that of noncompliance, and at that point, if your client doesn't come back and say, no, absolutely not, we are in compliance, why would we need anything more? Why would the board need anything more at that point? If there's no response, and instead, no, we were entitled to rely on something.
Mm-hmm. As I've noted, I do believe that we asserted we were in compliance, but that's really putting the cart before the horse, because the question here is whether the initial NOVs could have been issued at all. So the burden is not on the landowner to affirmatively prove compliance. That doesn't cure any error that there may have been in issuing those violations in the first place. Under our case law, it's very clear that the city has to strictly comply with its delegated zoning powers, and this process matters.
But it was proved by a preponderance that there was a violation?
Does what prove?
Is the burden simply a preponderance of the evidence that there's a violation?
I believe the burden under the zoning enforcement statute is credible evidence of an actual existing violation.
And Ms. Crawford, I know that there was at least an isolated reference by Mr. Slavin before the Board of Adjustment that simply asserting, well, the zoning administrator has not been on has not inspected since 2011 or whatever the date was. Would you also agree that there were statements made by the zoning administrator on more than one occasion that the property owners rejected efforts to inspect the property? They were refused.
There is only one statement in the record that I'm aware of where Sedona's counsel asserted before the Superior Court during argument that the Robesons had refused to allow them to inspect the gallery. However, they also expressly conceded that that issue was not before the board and it has been waived, and I don't believe that that argument is supported by the record. And again, we are confined to the record in this case since we're reviewing an administrative decision.
All right, well, we'll rely on the record.
Okay. Thanks, Your Honor. So turning back to credible evidence, even if you were to determine that there was a waiver issue with the statutory arguments under Issue 1, the credible evidence standard, it gets you to the same place. We can achieve the same result because there is no evidence in this record to support the issuance of the NOVs. And again, it's important to note that Sedona does not contend that the credible evidence argument has been waived, nor do they dispute that you have to have evidence of the actual existing conditions at the property. Here, the notices of violation were based solely on that withdrawn site plan. And again, that site plan is not in the record. Although we have descriptions of it, we're relying on uncorroborated testimony from the director to find these notices of violation. And I'd like to point you in particular to violation D5. I think this is a perfect illustration of the problem with the violations that we have here. That violation related to outdoor lighting. And if you look at appendix pages 144 and 216 to 217, again, that's APP 144 and APP 216 to 217, you will see that the only evidence in the record to uphold this alleged violation is the director's word. It's, I decided they were in violation. That was not covered by the chart summarizing the 2015 site plan and the CUP. There is nothing else in the record to support that, and that is not enough. And it looks like I'm cutting into my time, so I'd like to reserve the rest for rebuttal.
Good morning. Excuse me. Good morning, Your Honor. My name is Kristen Mackin, the law firm of Sims Murray, and on behalf of the SEDONA appellees. Okay, so I want to answer, before I get into what I prepared, I want to answer one of your questions that you raised regarding where in the Board of Adjustment transcript the zoning administrator referred specifically to the map. She was showing, I didn't see it included in the appendix, but clearly it was presented to the Board of Adjustment. They had the opportunity to view this map that was part of the zoning, withdrawn zoning plan. That was page 25, lines 21 through 24. She specifically refers to, now we're looking at the map that was attached to the zoning plan. But I kind of want to back up. I was going to start with standard of review, but I think we're all on the same page that because this is an appeal of a statutory special action, we're reviewing the findings, the decision of the Board of Adjustment, this court and the trial court, for an abuse of discretion or to determine whether the board acted arbitrarily and capriciously. What I think appellants are trying to do in this argument is reframe the issue so that they can have create a statutory question so that they can get a de novo review and get someone else to make a different determination than what the Board of Adjustment and the trial court have already upheld. But really, by arguing that she's acting outside of the scope of her authority, somehow that's in violation of the statute of 9-462.05, simply because she didn't, quote unquote, verify existing conditions. But as you've probably can tell from the record, that's directly contrary to her notices of violation themselves. And the very thorough staff report that she drafted, which very clearly held that she made a determination that the existing use of the property is in violation of the 92 CUP, the 92-3 CUP. The notices of violation say that the appellants continue to operate in violation. Staff has determined that Sun Silver West expanded beyond its scope. So there's numerous references throughout both of those documents that she made that determination. Then she presented in her staff.
Is there a cite to something other than staff has determined? Is the primary basis the application that was submitted and withdrawn?
No, she had additional, in the notice of violation and the staff report, she referred to additional basis for her decision. She had meetings with the appellants and the appellants' legal representatives, which the staff report thoroughly, they had a meeting with the appellants' legal representatives. They submitted a very detailed history and description of the property and their position as to the building permits that had been issued and their entitlement to certain rights they claimed. The staff report then goes through and explains and contrasts that with what she'd found. So she had relied in her determination on the representations from the legal counsel, her review of the withdrawn site plan, the representations as she testified at the Board of Adjustment meeting that were made to her, directly to her, as these are our existing conditions.
There are also complaints by adjoining
Property owners, yep, there was lots of complaints. She inspected neighboring properties, so it's not like she's never been near the property before. And she had staff observations listed as another reason in her staff report. And then when she testified at the Board of Adjustment hearing, I think she was very clear as to all these factors being a part of her decision. And then it was the job of the Board of Adjustment to determine whether that rose to the level of credible evidence in comparison to what evidence was presented by the appellants. She made her determination. She thought that was sufficient to issue the notice of violation because she had evidence of the existing conditions. She even gave appellants counsel an opportunity to respond in writing before she even formally issued the notices.
So, counsel, so Ms. Crawford's saying, look, there's just no evidence. Your position, I'm hearing, is yes, there was evidence, and it was up to the Board of Adjustment to determine whether the evidence was credible or not.
Your Honor, you've taken my argument. Yes, that's exactly it. No, and the trial court understood that as well. The appellants just didn't like her her evidence. They didn't like her testimony because it was contrary to theirs, but it was the job of the Board of Adjustment, the 5 people sitting there, to determine everybody's credibility as the witnesses. They saw them in person. They heard the testimony. I think the Board of Adjustment hearing was 4 hours or so there was a lot of testimony provided. There was a lot of debate and thoughtful consideration given, I think, to both parties' positions on that. And so it boils down to a question of credibility, and appellants tried this at the trial court with Judge Slayton. Appellant's counsel argued that there wasn't any competent evidence supporting the staff report, and Judge Slayton correctly noted that the argument that the staff report is not competent is really just asking him to substitute his judgment of credibility and competency for that of the Board of Adjustment, and that's not what I'm here to do. That was on page 170, lines 12 through 15 of the trial court transcript. A little later, he noted again, this is a decision as to whether or not I have sufficient evidence to overturn a decision of a Board of Adjustment. I have 2 equal affidavits completely opposite of each other on what's happened, and what you're asking me to do is to say, Judge, you should side with Mr. Cody Robeson. So the judge understood that despite the claims that there wasn't enough credible evidence to support the violations, the job of weighing whether that was credible or not fell to the Board of Adjustment.
Would there be enough if there were simply complaints by neighbors? Would that be enough evidence?
I think it would depend on the types of complaints. For instance, if a neighbor complained, I'm complaining about my neighbor building this giant monstrosity of a building in their front yard, that would be an open and obvious type of a violation. The city could check its records and see that there was no. I guess to answer your question, that was some additional work that the city might have done. If it was just staff or neighbor complaints, it would probably not be sufficient. Something else would need to be done, I would think.
Did SunWest try to rebut every piece of evidence, or my take on it, I guess I was reading it more along the lines of the equitable estoppel argument. But in your view, is there evidence that they attempted to rebut each suggestion that there was a violation and assert we are absolutely in compliance?
Absolutely not, Your Honor. Their primary argument at the Board of Adjustment was that we had this email exchange in 2011 with the then zoning administrator, and he said, what existing now? He gave us permission to have what we have now and to continue that. But they never said that they were still in compliance with the 92.3 CUP, which they wouldn't be able to do. One of their primary arguments, too, if we want to talk about specific violations, the D1 violation about the outdoor retail space, the 92.3 CUP clearly treats both tracts as a singular parcel and clearly says that you shall not go beyond what is existing now and then lists in the staff report what existing conditions are. That was 5,000 square feet of outdoor retail space. In the Board of Adjustment, they argue that meant that they got an additional 5,000 square feet of outdoor retail space. So they could keep what they had at that time, which at that time was located, I think, entirely on Tract 42. But they also, the 92.3 CUP somehow expanded their non-conforming rights, which was contrary to its intent and purpose, and gave them an additional 5,000 square feet. So that by making that admission and then saying, Judge, Board, it would be unfair of you to limit us to only 5,000 square feet. They're implyingly admitting that they have well expanded beyond the 5,000 square feet, and that's something you can probably see that they've nearly, according to their own admissions, they're at 14 or 15,000 square feet of outdoor retail space. They've nearly tripled. So that's something that I don't even think an on-site inspection would be necessary to see that they've gone beyond the 5,000.
Counsel, could you comment, is there something in the record other than the argument regarding the property owner's refusal to allow an inspection? Is there some evidence of that in the record, or was that merely an argument that was made?
I don't think we have, in the staff report, the ZA indicated property owners refused to allow inspections of the two neighboring properties, the Bowstring and the Era and the Tract 40 properties. So that is in the record. It is not in the record whether it was refused, an inspection was refused on the gallery properties. But in this case, I think that she had so much evidence, and the Board of Adjustment clearly agreed, she had so much evidence that they had gone so far beyond what the 92 CUP had allowed that on-site inspection in that instance wasn't necessary to give a verification of existing site conditions. And actually, we're using the word verification and determine, and that's not actually in the statute either. It only says that you can issue a notice of violation for existing use of the property. And I kind of wanted to talk a little bit about what the danger of taking the argument that you can't verify the existing use of a property without an on-site inspection. I think that would have a lot of very negative consequences because an on-site inspection is not the only tool in a ZA's toolbox. There's lots of other things. You have complaints, you have staff observations, you have things that are simply visible from the road. For instance, would an on-site inspection be required to verify the existence of compliance with front yard screening requirements? Certainly not. Whether an outside retail display is properly screened with the Land Development Code, the CUP talked about a fence and landscaping in combination. That's clearly visible from the road. You don't need an on-site inspection to view that. And it's an on-site inspection necessary when the property owner themselves makes admissions about their existing property conditions. Clearly, the Board of Adjustment found that the ZA's testimony was credible on that realm. So even if, and I think you were speaking about this with appellant, that say the ZA issues a notice violation, doesn't do an on-site inspection, there is nothing to prevent a property owner from saying, oh, whoa. That is not our existing conditions. Please come onto my property and take a look. And actually, just before the Board of Adjustment hearing, the Robesons did that, and that's why you see the discussion in the Board of Adjustment hearing with regard to the Bowstring and the Arrow properties, that those were removed at that time because they did come on, that ZA did go onto the property and verified that certain conditions did or did not exist, and so even at the Board of Adjustment, that notice of violation was in turn limited. So if the appellant has a concern or a problem with what is existing conditions, they were free to argue to the Board of Adjustment, but they didn't do that. They argued we shouldn't have to comply, or we don't have to comply because we have this other 2011 notice of email. And even if you did make us comply with the 92.3, we've invested a lot of money, and that's just going to be unreasonable. So
Ms. Mackin, maybe this is off the point. When the case was resolved at the Superior Court level, the judge affirmed most of what the Board of Adjustment did. But
5 of the 7.
But reversed part of it.
Yes.
Is there a cross appeal, or?
There is not. So the city is not cross appealed on the D5, which is the shielded, and the 6. And I'm just forgetting off the top of the shade structure. They decided the trial court thought that the existence of the unpermitted shade structure that was resolved in the 2011 email from Director O'Brien.
So the relief you're seeking here, if appellee seeks relief, is a straight affirm? Just
affirm the 5 violations that the trial court and upheld, and that the Board of Adjustment had found to be supported by credible evidence. So I can go through, if it's beneficial at all, I have like an explanation of the credible evidence supporting the remaining 5 violations, but I don't want to waste your time if you're on board.
It's your time.
Okay. So I think I already explained about the expansion of the outdoor retail space. That was D1. D2, I want to talk briefly about the expansion of the indoor space. And that was based on their admissions, staff observations, that there was two buildings, one which was permitted for a storage shed that was being used as indoor retail display, and so that wasn't included in the CUP at all.
So when you talk about expansion, you're not talking about physical expansion of a structure.
Expansion of the indoor,
Structure.
right, they built a new structure, they got an after-the-fact building permit for this outdoor storage shed.
But you're talking about changing the previously approved use.
Correct, it was, and their CUP said they were entitled to 2,250 square feet of indoor retail space, and so those are the covered areas. And the storage sheds, buildings A and B, I think primarily, were, it was, the ZA testified that those were now indoor retail space, whereas one was permitted as a storage shed, one was included in the CUP, but it was only included in the CUP as a workshop. She testified that it is now a retail space, and that those two buildings alone were about 1,000 square feet of additional indoor retail space above what the CUP had granted. So there was a lot of confusion, and I thought in the record, in the Board of Adjustment record with Appellant's Counsel was trying to pick out certain square feet that were or should have been included in the CUP, and the city admitted that maybe there was a few square feet, maybe the house was a little bigger than the 1950 square feet that was listed in the CUP, but that admission that there was some slight discrepancies in some of the square footage of the CUP didn't affect the ZA's determination that there was still at least two buildings, at least 1,000 square feet, that were still above and beyond what the CUP permitted, and that's why the Board of Adjustment included that as a firm, and I think that's why the trial court also affirmed that decision from the Board of Adjustment. And then as to the residence, that's the D3 violation, there was, the ZA determined that the house was not being used as a single-family residential dwelling. It was being used as an office space. The testimony at the Board of Adjustment hearing from Ms. Robeson indicated that it's being used as an art studio, part of a gallery, they conduct business, they store merchandise, employee kitchen and lounge, and any, conveniently omitted from that was any indication that they actually live there. So I think the ZA's testimony, the Board of Adjustment found that to be credible evidence to support that the home is no longer being used for a home. And the screening I kind of touched on, the D4, everybody agreed that there used to be landscaping along with this wrought iron fence that was removed by ADOT in relation to their highway project at some point, but then it was never replaced. I believe by the end of the Board of Adjustment transcript, they said, appellant said they were going to work on it, putting something back. And then D7, so they didn't really have an issue. I didn't think at the end with that being affirmed because they were in agreement that the landscaping was no longer there. And the D7, the back wall along the backside of the property line was erected without a permit. And the Board of Adjustment affirmed the ZA's finding, which really was just go fill out a permit application for your wall. And the trial court agreed. And at the Board of Adjustment hearing, the attorney for appellants also agreed, yeah, we'll fill out an application. So I think that the city would request respectfully then that all 5 of those that were affirmed by the trial court be affirmed here.
Since you've got a couple minutes, I would appreciate if you could take just a moment to talk about the waiver issues and specifically the case that appellants take issue with, Neal versus City of Kingman. Can you give us some thoughts about how little can be in the record below to support the continuation and perhaps recharacterization of an argument to avoid waiver?
Right. Well, I mean, I think there was an offhand reference that I think Buzz made at the Board of Adjustment hearing that, well, they haven't even inspected the property since 2011. And that seemed to be maybe the one fact in the Board of Adjustment record that they were relying on, that this issue about the notices of violation themselves being ultra vires or void or should never have been sent to the Board of Adjustment to begin with. But the fact remains, they never made that legal argument, and I think that their legal argument that the notices of violation should never have even been considered by the Board of Adjustment, that should have gone to the Board of Adjustment in the first instance, because that should have been a primary defense. Just the fact that she hadn't inspected the property, that leads to a conclusion that you have a competing evidence or credibility determination to make. But instead, I don't think this case falls into that, Neil. I don't think just offhandedly referencing a lack of an inspection since 2011 is sufficient to have preserved this issue on appeal. And then again, they didn't raise that issue. And this isn't even raised in the context of the board abused its discretion by considering these notices of violation. It was just that, nothing about the board, just that she shouldn't have issued the violation. So I would have thought that should have been raised in the first issue to the Board of Adjustment, or at least to the trial court again, and it simply wasn't.
Thank you. Before you begin, can I ask our bailiff how much time she has remaining? All right. We'll say it's an even 2, and go ahead.
Thank you, Your Honor. I'll be quick. So the basis for the NOVs, I think the record is very clear that they relied solely on the withdrawn site plan. Although they have argued in their brief that there were other bases, those are not supported by the record. If you go back to the briefing, the citations don't support it. They've also referenced neighbor complaints. If you look in the record, most of those complaints were about other properties, and a lot of them were duplicative. We have 5 complaints from one neighbor and his attorney. And again, it is not our burden to prove affirmative compliance. It is the director's burden in the first instance to show that there is a zoning violation.
Could they rely on concessions by counsel or testimony from Ms. Robson?
The board?
Could they?
They could, yes, but we do not believe that those were admissions. Those were alternative arguments offered, again, in the context of equitable estoppel, but the initial problem is whether there was any reason to be at the enforcement stage at all. And I would like to turn very quickly to issue number 2, because this is an independent basis. This is separate from issue 1 for relief on violations D2 and D5. Those violations were not decided by the Board of Adjustment and Superior Court. That is directly contrary to the statute 9-462.06G.
Can they decide by modifying the decision?
They can modify and decide. What they cannot do is effectively say, okay, you guys are going to go mediate it, but we're also going to enter an adverse judgment against you.
Even where the property owner and the zoning administrator agree to do that?
The correct course would have been to dismiss those violations or otherwise continue the hearing so you could come back and enter a ruling if they weren't able to reach an agreement. But right now, you're saying go mediate, but we also have an adverse decision on those 2, and it still leaves it up to the whim of the director. If we wanted to go back and say we didn't reach an agreement, we would have to it would start the process all over. And again, it's not our burden to prove our compliance. We would ask that you hold the director to her burden of showing that there was a zoning violation in the first instance. Thank you very much.
Thank you, counsel, for your arguments, and thank you to the audience for your attention. This court will be adjourned, and we'll take the matter under advisement.